Welcome once again to our YouTube video series on business contract law. My name is Christopher Neufeld of Neufeld Legal. And in this particular YouTube video, we're going to be discussing my rule of business contracts, which is the 75, 20, and 5 rule of business contracts. It's sort of a generalization that I utilize to describe the contents of a business contract, typically. Lengths may vary, but typically what I find is there's a 75% of the content of a business contract will be specific to largely template, 20% to selective template with some high degree level of precision as to what you select, and 5% for the guts. So let me go through what I'm talking about in these three components of my rule of 75, 20, and 5. Well, the first aspect is the template. Now there's some selection that goes about in this, but generally what you're talking about is you have template or boilerplate. That is the back end of the agreement. There's a lot of legalese, which absent some form of underhanded or deviousness with respect to what the contents are, typically are standardized legal principles and contractual terms that form the basis of the contract you're dealing with. Whether you're dealing with a commercial lease agreement, equipment lease, share purchase agreement, unanimous shareholders agreement, asset purchase agreement, mortgage financing agreement, security document, pledge agreement, collateralization agreement, you're going to find a large part of it is very standard and consistent throughout. And there's very little that's going to be changed from one to another. There might be changes with respect to the jurisdiction that you were in, such that it references to a different state or province, depending on the jurisdiction, and maybe a difference in the courts, an arbitration procedure or something like that. For the most part, it tends to be very consistent across the board. Then we're going to have the 20%, and this is more of an overall selective template, not so much boilerplate, but a selective template that takes a bit of choosing here and there as to what you're going to utilize, but it's not overly specific to the business itself. It's not written specifically for the business. Instead, you can pull it off of other contracts that pre-exist. It's just a matter of saying whether or not this belongs in the contractual agreement you're dealing with. And this is where you have a selection choice. Typically, you have the lawyers do this because they know what they're selecting between. But the idea is, do you want this principle to move forward with, or do you want another principle? For example, in unanimous shareholders agreement, we're talking about, do you want a shotgun provision, or do you want a put-call provision with respect to enforcement of sales when the parties have to come apart? Do you want a piggyback option, a tag-along option? What kind of optionality do you want? Those are the kinds of choices that you're making. They're very broad, they tend to be consistent, but not overly specific in the sense. That is where, when you get into specificity, that's where you come into the last and final part, which is the guts, as I call it, that 5%, where there's some real legal work, in my estimation, that has to be done to make a contract really fit what the individual is looking for with respect to their agreement. This is where the real legal work should come in play. Unfortunately, all too often you'll find that lawyers will focus too heavily on the first 95% and sell off those components and not really get into the guts aspect. They might work into some aspects of some of the numbers and the like, but they won't really work with you and really create the unique aspects that really define the business. Separate one agreement from another. allow the agreement to really provide either protections or really advance the business. And that's the critical component. So what your lawyer needs to be doing and what you need to be looking for when you work on these agreements is you really got to have that focus on the guts part. That's what you're paying money for with a lawyer, and that's what you need to be spending your time on. The other 95% is good, but that can really be done in a matter of 20 minutes to an hour for any lawyer if they know what they're doing. It's really in the core aspects, the really specific aspects, where you can build out the business ideas, where you can build the objectives that you need to be focusing on, that your lawyer needs to have you focus on, and that has to be worked on, because it represents the difference between having a great contract and a mediocre contract. Now, that gives you an idea as to how I perceive it. I think most people should start to look at their contracts that way, especially when contracts are so large. They have to be focusing very tightly on what should be focused on, and it's that 5%. Everything else you can really leave in most respects to the lawyer to make sure they're putting the right things in place and taking your thoughts. But it comes to the guts. The guts is where the heart of the contract is, and that's where you need to focus on. And that's where you need a business contract lawyer to help you stay focused and get the most out of every contract that you put in play. Thank you.